Thank you, Mr. Chairman. I very much look forward to the testimony of our three witnesses for whom we have waited, so I will attempt to be brief if I can. I welcome the opportunity to discuss the Supreme Court and some of the cases it has decided in this term and the past. The Supreme Court has, from time to time, endured criticism that its work has become politicized and that the decisions of the justices mirror their presumed political preferences rather than a consistent and transparent judicial philosophy. I myself have been critical of the Supreme Court and a few decisions with which I have disagreed. For example, the Citizens United case overturned precedent upholding the McCain-Feingold campaign finance law just a few years earlier. The Shelby County case invalidated key provisions of the 1965 Voting Rights Act, which had been upheld by previous Supreme Court decisions and had just been reauthorized by Congress unanimously, in fact, by the Senate 7 years prior. Indeed, leading scholars have said that this Supreme Court, after the transition from Justice O'Connor to Justice Alito, the Roberts Court, is the most conservative, by some estimates, in history. According to a 2009 article by Seventh Circuit Judge Richard Posner and William Landis, Justice Kennedy, who is the very center of this court, would rank, by their accounting, as the 10th most conservative justice since 1937. Time and time again, whether in Second Amendment cases, consumer protection cases, when considering affirmative action, reproductive rights, voting rights, campaign finance laws, this current Supreme Court has reached conclusions advocated by the political right, not by my party or those typically on my side of the aisle. It's therefore surprising many of my colleagues on the Republican side have reacted so strongly to two cases in which their advocates were unsuccessful. In the first case, King versus Burwell, Republicans were seeking to strip away tax credits that make health insurance affordable today for 7 million Americans. Opponents of the Affordable Care Act have lost repeatedly, first at the ballot box and then twice at the Supreme Court, most recently by a 6-3 supermajority, including the Chief Justice and Justice Kennedy, who are hardly routinely referred to as liberals. The charge that this court is engaging in liberal activism with the ACA is, I think, demonstrably false. The reading adopted by the court is fully consistent with the expressed will of Congress. Although Justice Scalia did not join in the opinion, the Chief Justice's textual analysis was very much influenced by Justice Scalia. Although Justice Scalia didn't join in the opinion, Chief Justice Roberts' textual analysis seemed to be notably influenced by Justice Scalia's jurisprudence. He quoted him to say that the fundamental canon of statutory construction, that the words of a statute must be read in their context and with a view to their place in the overall statutory scheme, is an essential underpinning of the majority opinion. To put it another way, justices must interpret a law's language within the context of what that law is trying to accomplish. Now, turning to the court's historic decision affirming marriage equality in Obergefell, the Republican assault on marriage equality is out of step, in my view, with the country and our values. Gay and lesbian Americans, long shunned or subjected to degrading treatment, inequality, and criminal penalties, have over recent years become valued full members of American society. Yet pockets of animus do remain. What the court decided in Obergefell is that marriage is a fundamental right and that same-sex couples, though a politically disadvantaged minority, have equal claim to it as do their straight fellow citizens. In so doing, I think the court was upholding constitutional rights against unjustified deprivation, which is what courts, and especially the Supreme Court, does best. The right cheered the Supreme Court when it did so for gun rights, or for campaign spending limits, or even the religious right of a nonprofit corporation. In time, I believe that bans on same-sex marriage will seem as backwards looking or out of step as bans on interracial marriage are seen today. And I would invite my colleagues to come and join the celebration of marriage equality and the steady movement towards civil rights that it represents. I just want to conclude by making a comment about the various reform proposals that have been introduced in anticipation of or in response to the Supreme Court's decisions this term. We cannot decry judicial activism and create a constitutional crisis every time that a big case comes out against us. We are blessed in this country, in my view, with the finest judiciary in the world. And for more than 200 years, the Supreme Court has mediated disputes involving states, the political branches of the government, private citizens, and I have disagreed with a number of its decisions. But the Supreme Court has been a vital arbiter of political interests precisely because it is insulated from the vagaries of politics and political interest. We should therefore, I think, reflect long and hard and exercise some humility on our own before upsetting that essential balance. Thank you, Mr. Chair.